Our next speaker is Professor Sumit Ganguly, who holds the Rabindranath Tagore Chair in Indian Cultures and Civilizations and is a Professor of Political Science and Director of Research of the Center on American and Global Security at Indiana University in Bloomington. He serves on the editorial boards of many journals, including Asian Survey, Journal of Democracy, Security Studies, and is also the associate editor of one of the leading publications in international relations, International Studies Quarterly. He is author, editor, or co-editor of 18 books, 18 on South Asia. His most recent books include The State of India's Democracy, Treading on Hallowed Ground, Military Operations in Sacred Spaces, India and Counterinsurgency, India, Pakistan and the Bomb, Debating Nuclear Stability in South Asia, and Asian Rivalries, Conflict, Escalation and Limits on Two-Level Games. He's going to speak to us today about quelling uprisings in India, normative, legal and institutional constraints. Thank you.
Thank you very much. At the outset, I'd like to thank Professor Inbar and the Begin Sadat Center for inviting me to this fascinating conference. My talk is divided into three distinct segments. First, I'll talk about my key findings by looking at the entire array of counterinsurgency operations that India has fought since independence in 1947. Second, I'll talk about the domestic constraints on the use of force. And third, I'll conclude by talking about where current doctrine and practice are headed in terms of India's counterinsurgency operations. These then constitute the three distinct components of my talk. To begin with, it's important to underscore that India had inherited certain colonial practices of counterinsurgency which were extraordinarily harsh and punitive, because the Indian Army until the 14th of August 1947 basically was an adjunct of the British colonial forces, and they had inherited the doctrines from the British colonial forces. And consequently, when first faced with a couple of uprisings on the extreme northeastern fringe of India, the immediate reaction of the Indian armed forces was to respond with a mailed fist. And this mailed fist was particularly brutal and harsh because it involved the destruction of entire villages, it involved the use of air power, and substantial cruelty directed towards the local population. But this was not entirely shocking, given that this was colonial doctrine. This was the doctrine that had been inherited. This is what they had been inculcated into them, and this is how they reacted when faced with the first uprisings in the Indian Northeast. Almost immediately after this first massacre, which involved the use of the Indian Air Force against hapless villagers, Prime Minister Nehru, India's first Prime Minister, immediately stepped in and stated quite categorically, which is a norm that still holds today, that when using force against domestic insurgents, the Indian armed forces must think of them as, quote, misguided citizenry, unquote, rather than enemies. And that principle, for the most part, with important exceptions, which I will allude to, has held with the Indian armed forces. So one cannot use sort of unbridled force against domestic insurgents. The same principle does not apply to foreign insurgents, a theme I shall return to somewhat later in the talk. Despite the enunciation of this particular norm, which, as I say, to a large degree holds even today, at the same time, Prime Minister Nehru was confronted with an important problem. Under the Indian Constitution, the Indian armed forces cannot be used in domestic circumstances. They have no authority to shoot at their own population. to enable the Indian Armed Forces to be used in what is referred to as aid to the civil operations. In effect, when civil authority simply proves incapable of maintaining order, or when a particular state is threatened by an insurgency, and civil forces and paramilitary forces prove inadequate to the task, only then can the army be called out. But the army could not be called out because there were no constitutional provisions for the use of the army in domestic circumstances. To circumvent this particular constitutional limitation, what was passed was a piece of legislation was passed called the Armed Forces Special Powers Act. And once invoked by either the national government or the state government, or the state government in conjunction with the national government, only then could the armed forces then operate within Indian soil and use force against any individual or group challenging the writ of the Indian state. The problem with the Armed Forces Special Powers Act is that it virtually grants impunity to the armed forces in the conduct of counterinsurgency operations on Indian soil. This is an important issue, and that's something I'm going to turn to in a moment. What are then the domestic constraints on the use of force? I would argue that there are three important domestic constraints that the Indian Armed Forces confront on a routine basis, especially today. First, there is extraordinary criticism, and much of it, frankly, uninformed, from domestic civil society and human rights groups about the Armed Forces Special Powers Act. They focus upon about 3 paragraphs within the Armed Forces Special Powers Act, which says, and I'll paraphrase, that an officer of the armed forces, as long as he or she is acting in good faith, may use force even to the point of causing bodily injury or even death in extreme circumstances and not face prosecution. The problem lies with the use of the words "in good faith." What then constitutes good faith? And this has become the subject of much legal commentary, and also not just legal commentary, but highly polemical and politicized commentary. The problem is that most of the critics of the Armed Forces Special Powers Act use a blunderbuss when a much more sophisticated instrument is called for. If you are asking for the jettisoning of the Armed Forces Special Powers Act, in effect, you are insisting that the armed forces can never be used on Indian soil because there is a constitutional prohibition. And yet, all of the criticism focuses on these 2 or 3 paragraphs that are genuinely controversial. Unfortunately, no one in this debate has given much ground, and as a consequence, the debate has become highly polarized, with members of the armed forces, and particularly retired members of the armed forces, who are at liberty to speak and are no longer bound by the constraints of office, launch broadsides against these groups, arguing that you simply don't understand that without the presence of this act, we simply will not be able to carry out any domestic operations. And at the same time, civil society and human rights groups refuse to engage in a meaningful discussion of the Armed Forces Special Powers Act and simply call for its blanket abolition. And as a consequence, the debate has reached a deadlock and is really a meaningless debate, because there is very little in the middle ground which recognizes this constitutional problem and at the same time does not want to grant complete leeway and lodge complete faith in the decency of the armed forces when dealing with domestic insurgents. That said, there is a fascinating inheritance from the Nehruvian period which still holds today and has again very recently become the subject of an important debate, faced with a particularly vicious set of Maoist revolutionaries who are trying to wreak havoc in various parts of India. And this involves the use of air power. Since that one tragic episode of the 1950s, the Indian Armed Forces have never used air power against either domestic or foreign insurgents operating on Indian soil. This is not an institutional constraint, but it is a normative constraint, but it is a norm that is so robust that has not been challenged by the armed forces until today. And even today, to be absolutely accurate about this, the challenge has not come from the armed forces. The challenge actually has come from the Indian Home Ministry, in effect, the ministry that's responsible for maintaining domestic law and order, where faced with a massacre, a recent massacre that took place last year of Indian paramilitary forces who were ambushed in northern India by these Maoist revolutionaries, the Home Minister opened up the possibility of using helicopter gunships against the Maoist revolutionaries. This set off a firestorm of controversy, and ultimately the controversy was effectively quelled when the Chief of Air Staff categorically stated that he would not permit the use of air power on Indian soil. So it is interesting to note that one norm that was developed quite early in the Indian state still remains firmly embedded and is likely to withstand challenges in the foreseeable future. So where does that leave us? There are two major themes that I will talk about in the last segment of my talk, namely current doctrine and practices, and where do matters stand as far as current doctrine and practices go. The first, it is quite fascinating that when it comes to dealing with foreign insurgents who are operating on Indian soil, and this principally involves insurgents stemming, and I will be blunt about this, from the state of Pakistan, mostly supported, trained, organized, aided, and abetted by the Inter-Services Intelligence Directorate of the Pakistani Armed Forces. And the evidence on this, by the way, is incontrovertible, and I'm not relying on any Indian sources. I'm relying on foreign sources ranging from The Guardian in Britain to the New York Times, neither of which, the last time I checked, were in the pay of the Indian government. So I suspect they can be considered to be reasonably dispassionate about this matter. These foreign insurgents operate with impunity from Pakistani soil. They were responsible for the brutal and vicious attack on the city of Bombay, leading to the deaths of 166 citizens around the 26th of November 2008. That has been the most recent and the most vicious attack on Indian soil, which obviously saw Indian security forces grossly unprepared to cope with, and we can get into that during the Q&A. And faced with these foreign insurgents who have absolutely no regard for human life, and more importantly, have no blood soil relationship with India, the Indian Armed Forces have developed a rather harsh response. And the response is one of no quarter. That they will shoot and aim to kill these foreign insurgents with impunity, and they do not face much domestic criticism when they do so, even from the most staunch human rights activists within India. That said, there are now increasing and growing constraints on the use of force against domestic insurgents. Why? Because of three important sources. One, there is increasing media scrutiny and surveillance of the actions of Indian paramilitary forces, Indian police, and even the Indian army. That is not considered sacrosanct. All three of these entities, whether it's local police, whether it's national paramilitary forces, or the Indian army, when they use force against domestic insurgents, they are under increasing and steady media scrutiny, particularly in the English language press, which is quite robust. Second, civil society and human rights groups also have placed an increasing burden of transparency and have increasingly scrutinized the behavior of the Indian forces when domestic citizenry are involved, even if domestic citizenry have taken up arms against the Indian state. Oh, easily, thank you. And finally, and this is an important issue that all democratic societies have to confront, and India is no exception in this regard. An increasingly activist judiciary. An activist judiciary that increasingly scrutinizes the behavior of the armed forces, the behavior of the police when they lodge particular cases, when evidence that has been obtained under duress comes under increasing pressure, and in fairness, one must also point out that even in an extraordinarily charged atmosphere in the wake of the terrible attack on Bombay in November 2008, quite recently a high court let an individual go scot-free because the High Court, in its wisdom, decided that the evidence that had been presented against the individual in this terrorism case was shoddy and really did not hold up under careful scrutiny, and it required an extraordinary degree of courage to rule in this fashion, because the mood against individuals even vaguely connected to the events in Bombay is not exactly warm and fuzzy. Quite the contrary, it's a sense that against these individuals, no quarter should be asked and no quarter should be given. So because of then growing media scrutiny, the growing influence of civil society and human rights groups, and increasingly the possibility of court rulings, the Indian armed forces will have to carefully examine how they deal particularly with individuals who are involved in domestic insurgencies. That said, I simply do not see these principles and these entities in any way significantly hobbling the use of force against foreign insurgents. There is a substantial consensus that these individuals don't belong on Indian soil, that they are being supported by a hostile power and constitute the agents of asymmetric warfare against the Indian state, and against them no quarter should be given. Thank you.
Thank you very much.